Welcome, everyone, to Tune Up Tuesdays, the Journey series that explores things that you want to learn more about, that you want to do better. And today is the very last segment. The series has gone so quickly. And today's segment is fantastic. It's Tune Up Your Estate Plan, Legacy Planning and Giving. We have two of our very favorite presenters, Doug Koenig and Michael Henkenius from UBT's Personal Trust and Wealth Management Division. I'm going to turn the presentation over to them. Before I do, I would just like to welcome Caitlin Moore back. We've missed her, and we're glad she's better. Thanks so very much. Doug and Michael, take it away.
Kelly, can you see the PowerPoint on the screen?
I can see, Doug.
Okay, thank you. All right.
Just remind everyone to use the chat feature for their questions.
Okay. Well, thanks, Kelly, very much. Michael and I are excited to present this to everybody today. And, you know, the topic, we've done presentations before on just estate planning and just providing information. So we're excited to kind of talk about that again, as well as add a little bit of some legacy planning and giving. So we'll just jump right into the presentation, and we're just going to start with a review of what we consider a complete estate plan. And these are the documents that would be included in a complete estate plan. One, you want to think about a last will and testament. Also, there may or may not be a trust as part of your estate plan. And Michael is going to talk a little bit later about different types of trusts and things to consider. Also, durable power of attorney for financial aspects, healthcare power of attorney as well. And then also, a really important part of the discussion is just not only beneficiary designations, but titling. And we'll get into that as well. So, and we would say if you're missing any one of these pieces, you probably don't have a complete estate plan done. So, you know, as you're thinking about that estate plan, and if you have yours done, you know, this is what we would consider that would make up a complete estate plan, as we've experienced in working with our clients. I put this up here real quick. You know, I think statistics would say that anywhere between 50 and 60% of people do not have an estate plan in place. You know, we see all types of different situations with family situations and things. And I kind of have a saying, it's not too late to get your estate plan done until it's too late. And, you know, as well as you want to make sure that you review it and tune it up on a regular basis as well. You know, the time that you don't want to be doing your estate plan is in a time of crisis. Now, if it ends up being that way, so be it. But, you know, the best time to think about creating your estate plan and tuning it up and reviewing it is when, you know, you're in a good situation, you have capacity to make your own decisions. You know, that's really the best time to be creating your estate plan and reviewing it and tuning it up. You know, and then once you do have your estate plan done, you know, it does bring great peace of mind. But what we always tell people is estate planning is never really done. I mean, laws change, tax situations change, your wealth changes, life changes, and all those. You want to make sure that your estate plan stays relevant to your situation and the situation that surrounds you and your estate plan when it comes to taxes and laws and things like that. So a review is very important on your estate plan to pull it out, dust it off, and read through it and make sure it's still relevant to your situation in life. So Part of that process too is just keeping an updated list of all your assets. This is important as you just consider everything. So, whether it's a balance sheet, personal financial statement, or just a list of those assets, and something that you can refer back to where you see all the different accounts that you have, how they're titled, what the beneficiary designations are, and what the current value is, because that can have an impact on how you do your planning as well. So, and as life goes on, people open up new accounts, people close accounts. I've even gotten into situations where a financial institution changed their software, and where did the beneficiary designations go at that time? So it's not bad to check in with some of those financial institutions just to make sure that they have those records the way you think you have them, and have this list to go by as well, as just as you consider everything and all your assets, and to make sure that it's all coordinated the way you want it to be coordinated. With that, we'll dive in just a little bit more into the documents, and for this next section here on the last will and testament, I'll turn it over to Mike. So.
Thank you, Doug. And Doug and I were joking beforehand that we had a great idea too late. We thought, since the title of our talk is Tune Up Your Estate Plan, we should be dressed as car mechanics. So we apologize for not being in costume for everybody, kind of brighten the subject up. But yeah, I'll kind of dive in here and get to speaking about really the first document that you should have as part of your estate plan, which is your last will and testament. And this is kind of the fundamental document in your toolbox. If you don't have a will, the state of Nebraska has one for you. So if a person dies without a will, they die, and it's called intestate, meaning that the state of Nebraska's probate code decides how their estate is divided up. And so most likely, Doug gave a statistic of the number of folks who don't ever get around to getting their will drafted. You're probably not going to like the way the state of Nebraska has planned for your estate if you don't have a will. So it's just very important that you direct how you want your assets to be distributed after your death. One important part of your will is a lot of us have maybe things that aren't real valuable financially, but they have great sentimental value. Maybe they have great meaning within our family, and that's some of the tangible property we may own. Here, think family heirlooms, your watch from your grandfather, or a favorite family painting. Those type of things you can specifically name in your will. And we have the opportunity to create what's called a laundry list, where we write out, and it can actually be in your handwriting or typed out, it's part of your will, where you name some of those tangible items that are kind of important to you and who you want those to go to. That's called a laundry list. And you can change that laundry list throughout your life, and you don't have to redo your will. It's kind of a nice flexible part of your will. For young parents, an important part, those of parents who have minor children, it's really important to have a will to provide a guardian. And that's someone who would, if something unfortunate were to happen to you and your spouse, this would be the person that really looks after your children, your minor children. So that's a very important reason why anyone with minor children should have a will. The will also could help you name if you have items of real property. Here, think things like real estate, maybe land or commercial property. If you have specific ideas for those, you can name those in your will. And then one of the vital parts of your will that you need to give great thought to is to who to name as personal representative. The personal representative, you may have heard the term executor, and that's the same thing legally. But your personal representative is the person in charge of collecting your assets, paying any bills you might have, paying the taxes, and then distributing what's left, or distributing the residue according to what your will says. So this is a big job. It's an important job, and it's a difficult job. And so you should think long and hard about who you should name as your personal representative. And that's why a lot of folks name Union Bank as their personal representative. You know, particularly today, a lot of us have family and our kids are spread out through all over the country. And it's a difficult job. If I live in, you know, in my hometown, if I have named my child who lives on either coast and it's my personal representative, it'd be hard for them to do that. And so that's where we add value to our relationships with our clients, as quite often they choose to name us as personal representative and really take on that major responsibility. Another important document in your estate plan is a trust. And a trust is an incredibly flexible estate planning tool. One type of trust is a testamentary trust. And that is a trust really that is created and it takes place after my death. Quite often I have my will and I have the language for my testamentary trust in my will. And it simply only takes place after my death, and it distributes my assets according to the terms of the trust language. And again, that's usually in your will. Another effective estate planning tool is a revocable trust, and that's created while I'm alive. I meet with my attorney, and we sit down, we draft the document, and we sign that. And then I continue to be what's called the trustee. I manage my assets, I manage my estate while I'm alive. But you have to think of a trust as kind of a basket that holds your assets. But if you don't put anything and title your assets into that basket, it really isn't worth much. So you make sure that you title assets like your car, your home, bank accounts, investment accounts, place them in that trust basket, and then you manage those during your lifetime. An important reason why to have a trust is you can name a successor trustee, someone who can step in if there's any unforeseen circumstances, contingencies, what ifs. Let's say I become incapacitated, maybe I have an extended illness. My successor trustee can continue to really pay my bills, manage my affairs while I'm incapacitated. Another important reason to have a trust is that if I have a trust, I can avoid probate. And many of you probably have heard the term probate. And while here in Nebraska, probate maybe is not as nasty as it is maybe in New York or California, it's still a court process. If you don't have a trust, you have a will. Your will goes through the probate process in Nebraska. That's a public process, and maybe that's not something you want to have happen. So if you have a trust, you avoid that probate process. And then finally, we've seen some clients that have maybe some children that have some disabilities. Maybe they're independent adults, but they need help functioning for whatever reason, whatever disability they may have. They can create a special needs trust to provide for that child and care for them during their life, even after I'm gone. But yet it kind of protects them from predators and other unforeseen circumstances. So those are all flexible reasons and great reasons why to have a revocable trust. Another type of trust is an irrevocable trust. And as you can probably tell by the title, it's something that's not changeable. A lot of times I'll create my revocable trust, and when I pass away, my trust becomes irrevocable. But it can continue then after my death. It can continue to provide for my family and my heirs, and maybe for a number of years or for their lifetime. We've listed some of the different types of irrevocable trusts there on our presentation. One of them is a charitable trust, and I'm going to talk about that in a little more detail later. Another reason to maybe consider some irrevocable trust planning is to sit down with your CPA and your attorney to see maybe you need to do some planning for wealth transfer. Doug's going to talk about here in a little bit the federal estate taxes and how in a few years that tax level is going to decrease. So there might be a reason for you to do some irrevocable trust planning to provide for a wealth transfer and maybe to avoid some federal state taxes. But another important reason and a benefit of an irrevocable trust is if I set that up for my kids or any heirs, it protects them from creditors. So it's set aside, it provides for their support, but no creditors can get to those assets, and it can continue to protect them and provide for them during their lifetime. So I'm going to turn it back over to Doug, and we'll take a look at some more tune-up ideas.
Thank you, Michael. So just to go, some of these documents are kind of self-explanatory, but just to go over them as part of your complete estate plan. And one, you're going to want to make sure that you have a power of attorney for financial. So that document allows you to name somebody to act as if they were you in financial activities, so that, you know, if you're not able to do that anymore, you don't want to do that, you're not in town while there's some type of transaction being done, somebody can step in as if they were you and still perform those transactions. It's somebody who can collect your income. It's somebody that can pay your bills. It's somebody that can gather all your information to get your income tax filed on a timely basis annually as well. So you're giving somebody the power to act as if they were you on all financial matters. Now, you can limit those powers. You can make them very general, and that would be, you know, a way to customize that power of attorney, just depending upon what your situation is. And but you don't want to limit your power of attorney so much that they can't do the job that they need to do as well. So another type of document, and we see lots of different things. So sometimes the financial and the medical are together, but most often I see the power of attorney for healthcare as a separate document. And it's essentially just you're naming somebody who can make health decisions if you're not able to do it yourself. And then a living will or advanced directives, again, sometimes the living will is part of the medical power of attorney. Sometimes it's a separate document. So, and the living will or advanced directives is all about end of life. So what are your instructions to the doctors on how you want end of life matters to go? So those are the other documents that help make up that complete estate plan. So the other thing I wanted to touch on today, because is titling and beneficiary designation. So I think a lot of you know this, but it bears repeating, but titling and beneficiary designations will supersede anything that you say in your will and your trust. So it's very powerful on how you title assets and how you have beneficiary designations. And there's different ways in which you can have ownership of assets. So that first bullet point, joint tenants with rights of survivorship. And so I think a way to understand that is just an example. Let's say a husband and wife own a checking account or a savings account as joint tenants with rights of survivorship. Well, what that means is they both own 100% of that asset. So if one of them passes away, the other one owns 100% of that asset. So by titling alone, you've created a path for that asset if one of you should pass away. Tenants in common is another way to own an asset. So that would mean that you own an undivided interest in some sort of asset. I think sometimes farmland might be the best example of this. Let's say mom and dad have passed away, and there's a brother and sister that inherit the farmland, but they inherit it as tenants in common. So neither one of them owns 100% of that asset. Instead, they own an undivided half interest. So if one of them passes away, the other half of that asset doesn't automatically pass to the other one. Instead, the brother or sister who passes away can contemplate how they want their share of that asset to transfer either to their family or someplace else. So, And then maybe the easiest one to understand is sole ownership, or you own something individually. And a lot of times the best example of this is a 401k or an IRA or a Roth IRA. You own it in your own name. You don't own it joint with anybody else. You don't own it as tenants in common. It's in your own name. So if you pass away, where do you want that asset to go? And that's where those beneficiary designations are so important. So there's, depending on the type of asset, it can either, that beneficiary designation can either be a TOD, which stands for transfer on death. It could be a POD, payable on death, or a lot of times the way we refer to beneficiaries in life insurance or IRAs or 401ks as a primary beneficiary, and then also contingent beneficiaries. And so asset titling and beneficiary designations are very powerful, and they really need to be considered so that you make sure that they're coordinating with your estate plan, and you don't actually unintentionally change your estate plan by doing something that doesn't coordinate with that estate plan. A few other things. Michael touched on, personal representative and trustee, and I touched on the power of attorney, which you name an attorney in fact. Well, when you name individuals or you name a corporate trustee such as Union Bank to serve in some of those roles, what I always tell people is, don't think that that's an honor in who you name to serve in those situations. I mean, when you think about wrapping your arms around somebody else's financial life and everything that's gone on, it can actually be quite a burden, and it's a lot of work. So you want to really be intentional about who you name in those roles. So one, do they have the time? Do they have the flexibility? Do they have the expertise? Do they have the experience? Are they good decision makers? Are they procrastinators? All those things you should think about when you're naming individuals to serve in those roles. And also another big thing with families is if you put one child in charge of the inheritance of all the others, sometimes that goes well and sometimes it doesn't go well at all. And that's really where Union Bank would excel as a corporate trustee, because if you name us to serve in some of those positions, we're not going to inherit your assets. We have a job to do. We have to look out for the best interest of every single one of those beneficiaries, and we follow your instructions in the document. So the other thing I just wanted to point out is your professional team. As you go through life, you start to build that professional team. And as you review and tune up your estate plan, it's important to just take inventory of your professional team. Who haven't you talked to recently? What things do you need to be running by them as you review your plan? What updates need to be done? What new tax considerations need to be done? I mean, rely on those people to be the professionals and the experts and gather their advice on things. So real quick, I just want to mention taxes. That's always a question when we're talking to people about estate plans. So, what are the death taxes? So we pay income taxes or file income tax returns on an annual basis, but what about death taxes? So the way things stand right now is all of us have the ability to give away $12.06 million at our death, and we will not owe any federal estate taxes. If you combine that with a spouse, that can be $24.12 million that won't be subject to federal estate taxes. So that affects very few of us at this point, but it's like Michael said, that law will sunset in December 31 of 2025. It'll go back to $5 million adjusted for inflation. And then sometimes you do get estates with farmland and things like that that it can really affect. So it's just something to keep an eye on. We do have Nebraska inheritance taxes. So we have a class 1 beneficiary in Nebraska. We have a class 2. We have a class 3. Class 1, after a certain exemption amount, pay 1%. And the estate normally pays these taxes. But A Class 2 beneficiary would be subject to a 13% tax, and Class 3 beneficiary would be subject to an 18% inheritance tax. So just, again, something to be aware of. And as you talk to your professionals, they can kind of guide you through that as well. The other thing to be aware of is sometimes we get the question of, well, how much can I give away every year and not owe any gift taxes? Well, the answer to that is you can give away $16,000 to as many individuals you want to, and you don't owe any gift taxes. Now, if you go over that amount, you could be subject to some gift taxes, or you could use up what's called your lifetime gift exemption as well. So just some things to think about, as you tune up and review and consider all your estate planning needs as you think about all your assets and the people that you want to benefit from that. And so we're going to jump into the next part of our presentation, just a little bit on legacy planning and giving as strategies in your estate plan and things that can be done. So I turn it back over to Michael.
Thank you, Doug. So maybe you haven't considered making charitable giving part of your estate plan or part of your end-of-life plans. I would just ask you, if you've been blessed and have some charitable organizations that are important to you during your lifetime, to consider remembering them and making them part of your charitable legacy through your estate plans. And so we thought maybe we could take a look at some simple ways to leave a charitable legacy. One of the first ways is a bequest in your will. And a bequest is just a legal term for gift. And many of you have probably heard that term. But it's a very, most of us understand the concept of a will, and the will is a perfect vehicle to make charitable giving part of your estate plan. It's revocable. So maybe I have an organization in my 60s that I name in my will, but things change throughout my life. You can change that designation with a change in your will. A lot of times we recommend people to name a percentage gift to charitable organizations. So you would say, I named my favorite charity a 5% beneficiary of my estate. That's flexible, and we don't know how much we'll have at the end of our life. And so rather than tying it down to a specific amount, we think that a percentage is kind of a smart way to name charitable organizations. But you can name specific dollar amounts in your will and just have that amount listed right in the designation. Beneficiary designations are a great way and a great tool for you to do some charitable planning as part of your estate plan. Maybe you've got an old life insurance policy, maybe it's a smaller policy you purchased, it's paid up. Your kids don't have any use for it, at least aren't depending on that. Consider naming a charitable organization a beneficiary of that life insurance policy. Or you could also name charitable organizations as the owner and beneficiary of life insurance policies. And that again takes place after your death, and you can certainly change a designation on your life insurance policy throughout your life. Two other assets I want to mention are IRAs and 401ks. And here again, you have beneficiary designation forms where you can name charitable organizations, maybe a percentage beneficiary of your IRA. You just need to simply contact your plan administrator and they can give you an updated beneficiary designation form. You fill that out, and then that gift has been made at the end of your life. You don't need to see an attorney, and you don't need to review your will or your trust. The reason why that's a smart way and a wonderful tool is that unlike individuals, charities don't pay income taxes when they receive IRAs or 401ks after I pass away. Let's say you have a $50,000 in an IRA at your death, and you've named your children as the beneficiaries. Well, they're not going to receive that $50,000 total. They'll first have to pay the deferred income taxes on that asset. However, if you have other assets to leave to your children, maybe you can name that IRA and name a charitable organization as the beneficiary. they receive 100% of that $50,000. They don't have to pay any of those deferred income taxes. So if you're going to do any charitable giving, look at those IRAs, those 401ks, and name those as beneficiaries. Some of us want to make gifts now, right? We want to have the joy of giving while we're alive. So qualified charitable distributions from your retirement account or QCDs are a real effective tool. This is an outright gift. Again, this is while you're alive. You must be 70 and a half or older, and your gift goes directly from your IRA to your charitable organization. It can be a public charity. It can't be a donor advised fund that you've set up. And there's a limit each year of $100,000 that you can't go over as far as making a qualified charitable distribution. Some of us have, I've talked to some clients where they have to take out required minimum distributions from their IRA. And they tell me, Michael, I don't need the income. So instead of having to draw that out, report that income, and pay more taxes, we tell clients, think about making a qualified charitable distribution of your required minimum distributions. Give that to charity. They benefit from a gift. You feel great about making that gift, and then you don't have to report any of that income. So those are some simple ways to make some charitable giving part of your estate plan. One advanced way to leave a charitable legacy is a charitable trust, and we kind of touched on this earlier. A charitable trust is an irrevocable trust. I sign it, I draft it, and once it's drafted and signed, it's irrevocable. It's a way for me to put an asset into the trust, sell it tax-free, provide an income stream to myself, or maybe myself and my spouse for our lifetimes. And then at my death, it pays out to charity. This is kind of an effective tool in certain circumstances. Some clients we have, maybe they have appreciated stock they bought a long time ago. It's really grown in value. If they were to sell that, they'd have to pay a lot of capital gains on the sale of that stock. Maybe that stock isn't paying them a lot of income. Maybe it doesn't kick out a lot of dividends and interest. One way to get more income out of that is to donate that stock into a charitable trust. Then we sell it tax-free, and then it can produce more income to you for your lifetime. You can also set up a charitable trust just to last for a number of years, a term of years. So that's a great way to maybe use an asset. Maybe farmland is another place where this charitable trust idea works well. And you name a trustee to manage the trust during your lifetime. And we serve as trustee on lots of charitable trusts, and we kind of provide, again, as Doug mentioned earlier, that corporate fiduciary professional management, a chance to grow that asset during your lifetime, maybe provide more income to you than you had before, and you make a great gift to charity. Finally, just want to leave you this last point. Your estate plan is really your last chance to show your family and to show the community what organizations were important to you during your lifetime. And a lot of our charitable organizations have endowment funds, and those are perpetual funds that maybe are attractive vehicles for you to leave an estate gift to, either a will or through your trust. It's because they're permanent, they're perpetual. The charitable organizations won't spend your end-of-life gift. They'll just continue to use the interest from it. So that's one benefit, and maybe that gives you some comfort and maybe inspires you to make an end-of-life gift, to have that permanent endowment type gift. And then the last bullet you see there is private family foundations. This is a case where families have a large amount of assets and they want to set up kind of a permanent charitable organization, but it's a private family foundation that lasts maybe perpetually or for a number of years after their death. It's a chance for your family kind of to come together and be involved in the decision-making of giving money to charitable organizations. You can set this up during your lifetime, or you can make it part of your estate. So if you have questions about these charitable gift ideas, I'd encourage you to visit with Doug and I, and we can kind of dive into them in a little more detail.
Thanks, Michael. So a lot of good information there on some of the charitable giving things for all of us that we could do. I think Michael presented everything from those who have something to give to those who have accumulated a lot of wealth and are looking at some bigger projects as well. So we just wanted to throw this up here on the screen just to say that today we're just providing information. Don't think any of this was legal advice or tax accounting advice or anything else. So, but it's just things that we've learned in our practice that we wanted to present to you today. And I'll leave this up here just a little bit if you want to take down a number or an email. So feel free to get in touch with us if you have more questions or anything we can do or provide for you. So with that, Kelly, I'll turn it back over to you.
It's back over to me. That was a fabulous presentation. Thank you so very much. I would like everyone, even though you can't hear them, to give Doug and Michael a big hand because that was fascinating. We do have some questions here. The first one is, when did the gifting amount changed to $16,000?
This year,
Yep.
January 1, 2022. So.
Okay,
just
there you go, Dennis.
And for those who didn't know, I mean, it was 15,000 the year before that. You know, it's kind of funny too, Kelly. So sometimes we'll sit down and talk with people. And actually, this is a good example of, you know, talking to your professionals every once in a while. And, you know, it's been, I don't know, 10 years since we talked to them, and we sit down and they'll say, well, we're still gifting 10,000 to our kids. Well, they don't know that it's gone up substantially over the years. And so another good reason just to get that current information. And so, you know, just this year, it's now moved up to 16,000. So
Remember, for married couples, that's per person. So, you know, effectively, if you have a child, both spouses can be making those gifts to children. So don't forget that as well.
Okay, great, thanks. I bet your client was disappointed that they missed that opportunity, and I bet their adult kids were really disappointed they didn't get that raise. So anyway, I have a request of you to share the requirements of the new Nebraska state law for power of attorney for digital documents, etc.
So there is new language that can go into those power of attorney documents, and that wasn't contemplated prior to all these digital assets that we have. And so there is specific language in the Nebraska state statutes now that can go into that power of attorney document so that the agent would have power to handle those things. Now, you can just, you see different types of power of attorney documents, but it's actually in the code. So if the code is referenced, you don't have to actually have the specific language in your power of attorney document for them to have the power, as long as it says according to state statute such and such, that power is still in there. So sometimes we'll read documents and, well, it's not in there. Well, yes, it is, because it references the state statute. So. And, I might mention one other thing too, Kelly, as I was thinking about the list of assets. So another new asset that we're starting to find people to have is cryptocurrency. And that creates a whole new realm of administration for us. And with the cryptocurrency, what people really need to think about is, and I think you guys have heard the stories, or a lot of you have, there's a blockchain to that. And if you lose the passwords or the credentials, then that asset could be lost forever. So, you talk about passwords and things, where is the right place to store those things? Who should you tell about those things? you know, one thing here at Union Bank, we do offer to safekeep original documents if people have named Union Bank in their estate plan someplace. And if you want to think about that, if people take us up on that offer, we've created a physical space in our vault in which, you know, we can store information for people as well in a safe place.
That's really good information. Thank you. Cynthia would like for me to ask you to restate the 5 professionals you should have on your team.
And Cynthia, I wouldn't say that's an exhaustive list, and I'll let Michael.
Sure. We had that on one of our slides. So think about having an attorney, CPA, tax advisor, insurance representative, and investment advisor. We kind of had those 4 priorities, and we listed others in there as well. But our point there was, you know, make sure that all of your advisors are working for you, and you're communicating your charitable giving or your estate planning and what your plans are with your entire team. They should be working for you and keep everyone informed. So that Doug said that's not an exhaustive list, but those are 4 important people.
Yeah, and I even think about your personal banker, your branch manager, you know, even retirement plan services area. I mean, whatever your assets are touching and whatever experience and expertise you need, yeah, that needs to be part of your professional team.
Yeah, and just to put a plug in for our private banking group, you know, those, if you're looking for like a quarterback to kind of oversee your team, that's what our private banking group is for. They can kind of be your one person of contact that kind of knows what's going on and can communicate with your team. So if you want to learn more about that group, you know, sure, visit with Doug.
It's a great analogy. Thank you. This one is, should I let my charity know that I have named them as a beneficiary?
Great question. You know, a lot of folks you don't need to, but I'll tell you, I worked in the nonprofit world before coming over to Union Bank, and it's a good idea for the main reason that you want to make sure that your plan is something that they need. And if you're super specific with what you want your gifting to be, you need to make sure that maybe it's a specific program, that's going to be around years from now. So it's just like anything else. I think the more you communicate, your charitable wishes will be carried out. So I would encourage you to let the charitable organization know. A lot of our charities have planned giving societies, and they're groups of like-minded philanthropic people who have named, you know, maybe their favorite charity with an estate gift, and they like to thank them because you know, we don't get that satisfaction while we're alive of doing an estate plan. So it's a nice way to get involved. But I think to make sure that your goals are carried out, it's a smart thing to do to visit with the organization, and they might have some ideas for you on how best to, you know, the best wording, make sure the legal wording is correct, and how best to structure your gift and make sure it does what you want it to do.
Great, thank you. We have another. Keith would like to know, what about digital wills, passing on account passwords?
Good question. I don't have a lot of experience with the digital wills, but Doug, you have any?
Well, so in Nebraska, I mean, I think you have to have an original will at this point. Keith, and I think you're probably pretty knowledgeable in this area too. So, but passing on account passwords, that is something of consideration. And like I said, I've had people do different things. Somebody else had like a digital password wallet where they had accounts and password information. They wrote that down, put it in an envelope, sealed it, signed their name on it and dated it, and we put it in the vault with their other estate planning documents. There are different softwares out there to help on those password situations. Some people write them down and have them in a specific spot, and we have notes in our file on where to find such a list in their house should something happen to them. The other thing too is some of these, digital assets and things, they will require you to change your password every so often. So, it's another big chore to kind of keep that up to date. So there's multiple ways to do that. And I guess you just kind of have to find your best way to make sure that people know what they need to know if something happens to you. And we're happy to be a part of that. So.
Thank you. Are there any other questions for Doug or Michael? Okay. Well, if you don't mind sharing, well, we've already closed the PowerPoint. I was going to ask you to share your contact information one more time.
No, I can do that easily.
That would be perfect. Thank you.
Oh, there we go.
There you go. If you'd like to contact Michael or Doug and glean some more knowledge from them, more specific to your particular situation, I would encourage you to do so. I thank them again for their time today and sharing their expertise. Thanks to all of you for sharing your Tuesday afternoon with us. Thanks again to Caitlin Moore for helping us out. And this concludes our Tune Up Tuesday series. But we'll be back soon with something else great for you. So thanks again and be well. Bye-bye.